I'm Judge Joel Clouser, and I've been the Justice of the Peace for 25 years. And this is Precinct 2. First of all, our purpose is to apprise you of the law. Background. A lot of people don't know this. There's 3 branches of government. Some of you know this. There's the legislative branch. The legislative branch makes the laws. We just happen to have State Representative Ron Reynolds here with us. He's in the legislative branch of state government. This is the man who makes the laws. So if you don't like the laws, jump on him. I'll put that on you. Go ahead on it. You may.
I just want to say good evening. I want to thank Judge Clouser. Before I thank him for hosting this, many of you may know from social media, my family and I had to evacuate our home because of a mandatory evacuation. The flood waters were very high and we couldn't navigate in our neighborhood, and the county issued a mandatory evacuation. Judge Clouser and his wonderful wife, he said, "Hey, you got a place to go?" I said, "Well, not really. We just all of a sudden had a mandatory evacuation. We're working it out. Come on over here." I said, "Judge, I don't want to intrude." No, you're welcome. He's more than a public servant. He's a good father. He's a great husband. And he's a great Christian man. He's a great leader in this community. So, Judge Clouser, we really appreciate you. You're always fair and balanced. I know you never give deference to the tenant or the landlord. That's what makes you a great judge. You're fair and impartial. And everybody I've known that's been in his court, whether they like the result or not, they said he was fair. There's always a winner and a loser, but he's right. The legislative branch makes the law. If you want the laws changed, then you have to see me. So thank you and God bless you. Thank you, Judge. Appreciate you.
Thank you very much. Thank you, Ron. All right. And the executive branch enforces the laws. They don't work for me. They don't work for me. All right. They're in the executive branch. They enforce the laws. And we just happen to have law enforcement here in the courtroom today. We have Constable Gary Majors. Constable, come on up.
A little bit about Judge Clouser, and I'm going to put him on the spot a little bit.
Okay.
He's been here 25 years. This October, for me, it'll be 23 years serving this community. And I remember when he was in the Arcola, Fresno area, I was one of his first bailiffs. One of his first bailiffs. And, through the years, I've seen him bailiff here, and fair. Always fair and willing to listen. Doesn't have to, but he does. And I think he's been doing an outstanding job for these past 25 plus years.
Thank you. Thank you very much.
Yeah, you're welcome. Yeah.
All right. Thank you. Thank you very much. Okay, now we come down to the judicial branch, and that's me. We interpret the laws. So when you get a ticket, if you say guilty or no contest and you're fined, okay, good. Now, if you say not guilty, then you go to trial. And that's where I hear the evidence. I hear both sides of the story, and I render a verdict. Now, let's talk a little bit about the Justice Court. We have a criminal docket and we have a civil docket. Now, a criminal docket consists of non-jailable offenses, so it's very minor crimes, Class C misdemeanors, kind of crimes you commit and they don't take you to jail. Okay, the only way we can take you to jail if you don't show up on the date on the ticket, or if you are fined, convicted, and you never pay the fine. That's the only way we can take you to jail, all right? We also have a civil docket, and we cover 4 types of cases in the civil docket. We cover debt claims. That's where the bank brings them into court and sues them and gets a judgment if they don't pay the credit cards. All right, and then small claims. Y'all seen Judge Judy? Okay, I try not to be like Judge Judy. All right, and now Judge Judy's jurisdictional limit is $5,000. Our jurisdictional limit is $10,000. Okay, so we go up to $10,000. Then we handle evictions, and this is what we're here for tonight. And that's a suit for possession. That's where the landlord sues for possession of the real property, and also can enjoin a suit for back rent and court costs. Okay, and then we have repair and remedy. That comes out of eviction cases. All right, and that's when the landlord doesn't fix anything. There's certain conditions in which you can sue the landlord. It's called repair and remedy. All right, let's talk about evictions. That's what we're here for tonight, to talk about evictions. Remember I said, that's a suit for possession. And the landlord can enjoin a suit for back rent up to $10,000 and court costs, all right? Now, let's talk a little bit about grounds for eviction, all right? The landlord, if you're a tenant and the landlord brings you to court, okay, these are some of the reasons. 90% of my case filings are non-payment of rent. That's when the tenant does not pay any rent. And the landlord has a note got to make every month at the bank, and he says, wait a minute, you got to go, all right? So, and also if you don't pay the late fees, you don't pay, if it's in your lease that you're supposed to pay for the utilities, if you don't pay the utilities. Now the next big reason why people are evicted is because of pet violations, right? When you move in your lease, it'll say no pets, or if you're going to have pets, you got to pay a pet deposit. You don't pay that pet deposit, then you have what's most common is pit bulls. Does anybody have a pit bull? No one wants to admit to it, huh? All right. Pit bulls. Now, and the reason for that is because animals really wear on property. They really wear on property, so they cause a lot of damage, and that's why the landlord requires such a high pet deposit. And the next one is destruction of property. We have tenants who destroy property. The landlord has a right to go in and inspect. It's in the lease. And they see the property is all torn up. The next is the neighbor from hell. Have you ever seen a neighbor from hell? Plays loud music and you can't get no sleep. They party all the time. And then the next reason is prostitution. All right? And that's one of the big ones. The next reason is that the lease expires or there never was a lease. And then all the landlord has to do, the landlord says, I want my property back, I want to sell it, I want you out, or I'm sick of you, you've been paying rent for the last year late, and I'm sick of it, and all he's got to do is give a 30-day vacate notice. He doesn't have to give a reason, 30-day vacate notice, all right? Now, violations of deed restriction covenants and also violation of city ordinance. Missouri City has a tough city ordinance, all right? And they require you to have a garbage can in at a certain time. You can't put it out before a certain time. You got to put it in at a certain time. And if it continues to happen, some of the tenants will leave the garbage can out all week. And what they do is the inspector comes by and fines the landlord, the property owner. Okay, they don't fine the tenant, they fine the property owner. The property owner tries to get his money back for the fine, and the tenant says, I'm not giving you the money for the fine, and then he brings them in and he evicts them, all right, because it's costing him money. Also, high grass, people who don't cut their grass, okay, and also deed restriction violations. In any rental situation, the lease rules is what you must abide by. You sign that lease, the lease rules, okay? And the lease will stipulate the term of the lease, usually it's 1 year. Also, how much the monthly rent is, when the rent is due, and usually it's due on the 1st. And any late fees, if you pay it after the 3rd day or the 5th day, you owe late fees. Also, the security deposit. And usually when you move in, the landlord wants 1 month's rent plus the security deposit. The security deposit is usually in the amount of 1 month's rent, okay? Now, a lot of people come in here and they say, well, I paid the first and the last month. That's not so. You paid the first month and you paid the security deposit. Now, the security deposit cannot be used in lieu of rent. So if you say, well, you got my last month or you got my security deposit, use it. Can't do it, all right? And the security deposit is to cover the damages due to negligence, not normal wear and tear, but due to negligence of the tenant or the tenant's guest, like windows busted out and things of that nature. Now, the way you get your security deposit refund is usually and it's stipulated in the lease, you have to give a 30-day notice and a walkthrough so the landlord can see. You got to tell them, well, it's a 30-day notice to move out. You know, you let them know you're going to move out, give them a walkthrough, and the forwarding address where you are moving to so the landlord can send you either the security deposit, or list the itemized deductions, okay, for repairs, and then the remainder of the security deposit. Okay? Now, at the time you do it, you cannot owe back rent. If you owe back rent, you're not entitled to the security deposit. If you don't have a lease, then how can the lease rule? Texas Property Code rules. Texas Property Code rules. All right? And you'll find most lease is straight out the property code. Straight out of the property codes. Let's say if the lease expires, you still got to abide by the terms of the lease. You still got to. You move into somebody's house, it's an implied contract. You don't own the house and you're living in the house, it's an implied contract that you're going to pay rent. You're going to pay rent, okay? So, the terms of the lease still apply, except only one thing. The landlord can give you a 30-day vacate notice. So you're protected if you have the lease, all right? And you must abide by the conditions in that lease, by the covenants in that lease. Let's talk about a little bit about the eviction process. The landlord, if it's non-payment of rent, the landlord must give you a 3-day vacate notice. Now, it can be in person. He can hand it to you in person. He can mail it, certified mail, or he can have it posted, or he can post it on the door, on the entrance door. A lot of landlords post it on the garage, they post it on the back door, they post it on the front door to make sure you got it. All right? Now, then they come, if you don't move in 3 days or you don't pay up the rent, then the landlord comes in and they file in the JP court in the county and precinct where the property is located. All right? All right, so if your house is in Hunters Glen, you're in precinct 2, they file it in here. Okay. Now, the citation will be served by the constable, either personal or the constable will post it at least 6 days before the trial date. By posting, I mean we'll post it on the door. And service is perfected. We will proceed with the trial. The trial will take place no less than 10 days or no more than 21 days, all right, from the date of filing. Then you do have, now somebody asked, what about a jury trial? Was that you? You have the right to ask for a jury trial. Everybody, that's the wonderful thing about our country. You can ask for a jury trial, okay? Now, but you have to pay $22 for the jury fee. It went up. If you're poor and you're a pauper, you can file what we call a statement of inability to pay. We call it commonly known as a pauper's affidavit. And that's where you have to fill it out completely. And you have to explain that you don't have the funds, especially if you're on like housing or you receive WIC, Social Security. All right, that's one of the parameters that determines whether or not you file as a pauper. You can file as a pauper, okay? A lot of times a tenant will ask for a jury trial. I know in Harris County it takes about a month to pull together a jury trial. Well, in Fort Bend County we have a jury coming in every 2 weeks, okay? So just wanted to let you know that. All right, now, during the trial, let's say after the trial, the verdict is rendered and it will be either rendered for the plaintiff or the landlord, plaintiff landlord, or the tenant defendant, okay? Now, if the tenant fails to appear, it's going to be a default judgment. If the landlord fails to appear, we dismiss the case. The landlord's got to be here to present his case. After the judgment, if the tenant is ruled against, the landlord can file for his writ of possession 6 days after the judgment.
What is the time frame that we're talking about? Presumably, under item 1 for 3-day vacate, there's already been a certain amount of time that has passed without rent being paid,
Yes.
okay? So then we're looking at, you said forbearance is 2 weeks.
Well, if it's for jury
So you're
trial,
looking at
yeah.
potentially another month or more.
Well, it depends on when they ask for the jury trial. Sometimes they'll ask for a jury trial on a Monday and we'll say, oh, we got a jury coming in on Wednesday. So it could be like that, yeah.
So during that,
It's a process.
that process, that would still, you go to item 7 and let's say it goes against the tenant is still then responsible for the rent, back rent, and up until the time they vacate?
No, when the judgment is final, and that's it,
Okay.
all right? There's no new trial in an eviction case. We have people who file a motion for a new trial. There's no new trial in an eviction case, okay? Only thing you can do is appeal, and you have to do it in a timely manner. Writ of possession. Some people say, what's the writ of possession? And that's in order to have the constable remove you from the premises. The constable gets an order to go out. They get the writ of possession, the order to go and remove them from the premises. Now, let me tell you, that ain't pretty. That ain't pretty. If you don't open the door, they have a tool that pops open the door. And they put your furniture and all your personal items on the curb. Now, any landlords in here, don't you go and remove a tenant, all right? You can be sued. You can be sued. All right. Sergeant, the question is just what is the process? When you go to move somebody out, what do? You have a landlord meet you out there?
Yes.
With 2 strong guys? The landlord has to,
No.
Okay,
No,
okay.
to make like the judge said, we used to use the bonded warehouses, so if we did a move out, it really looked like you was just being moved out. But now, we put your stuff right on the curb, so it's a little different. The landlord is responsible for getting the movers that we need to move your stuff out. So, and I know a lot of times that you're probably behind rent or they haven't paid you rent, so we try to move this kind of fast. I would request 6 to 8 movers. That's what I request. If you don't have 6 to 8 movers, we're probably gonna cancel it because we don't wanna be out there all day moving the property out. So we'll get 6 to 8 movers and a locksmith. I'm gonna go in, I'm gonna clear the whole house, make sure they have no weapons or anything inside of the house. When I come out, I'm gonna call my locksmith, you start changing the locks. Then I'm gonna get my movers and we're gonna go room by room and they're gonna move everything out onto the curb.
That's more money we have to spend. Get the people out of our place.
And that's true.
I'll come back
That's
on
true.
the 28th.
And the same thing the judge is doing here, I'm normally doing the same thing on the curb,
Okay.
explaining it to the landlord because they don't know the process.
It used to be a time where you guys did it long back.
Yes,
in the
and
day.
it really, I was not a fan of putting it on the curb. I really wasn't, because we've never done it, but now I kind of like it because we can get a lot done. So today I done 2. I done 2 today. There one at 8 o'clock, one at 12.
But I think that other way probably would be better because I think if somebody, you might have some people who can afford to pay rent and just run into some hard time versus people, they can afford to pay rent, they just don't. Versus if you're already going through hardship, that's the last you need for somebody just to throw your stuff out.
Right, and
I
we
know
definitely.
as a landlord, you want your money, but at the same time, to me, it'd be nice if there was some kind of compassion, just instead of throwing people's stuff out.
Okay, and it's definitely compassion. We're not just throwing your stuff out. It just looks bad. It looks bad it's no way around it where it looks good because your stuff is actually sitting right out on the curb. Now, I'm gonna be there while your stuff is out there. Nobody's gonna touch it. Nobody's gonna steal anything from you. And I'm gonna tell you, okay, we're gonna put everything out. What you need to do is you need to go get a truck right now. While you gone, we're gonna be putting everything out, and when you come back, you can get all of your stuff. Nobody's
Move it
gonna
to
touch
storage.
You don't have to worry about none of that.
So y'all will wait and keep
Yes.
people out of their stuff?
Of course, because if we don't wait, your stuff will be gone.
Yeah.
Since we've had Hurricane Harvey, a dwelling is uninhabitable. Now, the landlord can move you to another one and let you live out the old lease. Okay?
To Harvey. We had some damage in the house that we
Sure.
And can't say it's not livable, but it's unsightly and like mold and whatnot.
Sure.
And we've talked to the landlord several times about this situation.
Sure.
And we have not heard anything from him. In this situation, what do we do? Do we file?
First of all, you got to go in writing. He's probably waiting on his check from the insurance company. Okay, you got under normal circumstances, and we're not talking about Hurricane Harvey, but he would have about 7 days to remedy that. Okay, now, but under these circumstances, you've got to understand he's got to wait on his insurance check, and then you've got to give him about 30 days to remedy the defect. All right. And the reason for that is because materials are hard to find. Everybody is going to Office Depot and Lowe's and buying up plywood and 2x4s. And so they got to wait for more materials to come in. Also, contractors, you got to get in line. Contractors, they say, well, I can't get to you until next month. All right, so now all he has to do is give you an affidavit of delay in writing, and let you and spell out specifically why there's a delay. Okay?
What's the time?
What box means is that it's black mold.
Yeah, black mold.
And it can cause health problems.
It sure can. All right. And if it's causing health problems, okay, first of all, you might want to get a doctor's statement. You might want to get an expert to come in and say this house has mold. Yeah, and I'm talking about bona fide expert. Not your brother-in-law, not your uncle. All right? Okay, to come in and say this house is infested with mold. All right? And then you just terminate the lease and move. Do not withhold rent. Okay? And then if he doesn't fix it, like in, let's say 2 months or so, a reasonable period of time. And who's to determine, that might be determined by the judge. He'll argue that, that I couldn't get it fixed because of problems finding the contractor or problems finding materials. And, you'll argue that, hey, wait a minute, I'm sick in this house. Okay, so reasonable period of time the judge will decide. But you can terminate the lease and give him notice, I'm terminating the lease, and move. But do not withhold rent. That is not the solution. Okay.
One of the ladies that live there has a 2-bedroom apartment. Her daughter and her husband and their son, who is disabled, lost everything. The house, their business, their 2 cars, and their 2 motorcycles. So they are staying with her mother.
Sure.
Okay. And it's when she signed up, she was told that you could have visitors 2 days a month. When I signed up, I was told I could have visitors 3 days a month.
Where is this?
Well, this,
No, I mean, you're saying visitors.
if someone in your family needed somewhere to stay, they couldn't stay no more than 3 days a month.
Oh,
And when she signed up, they were told 2 days a month. But these are different managers for the same management company. So now this lady,
Apartment complex?
Apartment complex. Her daughter is there now due to the hurricane.
yes.
Have no place to go. And
Right.
have nothing to go back to.
Okay.
And the hotels that they tried to get to are already full.
Sure.
So, what we are wanting to know is, since it's not stated in our lease anywhere
No.
about how many days somebody can stay there or whatever, can that person be evicted when they have been told that this person has to be out by tomorrow?
And the disaster conditions that we've gone through is something totally new. We didn't anticipate this. And I think if you go in writing and state the reason for it and how long they're going to be there, and usually on a lease, especially apartment lease, well, all the leases, they tell you have to list whoever's going to be the occupant. How many occupants, okay? And the landlord can, if you have other occupants there, the landlord can. It's that, as I said, that lease rules. But I would go in writing. And now most landlords are compassionate because of Harvey. Most of the landlords, I've found that when we had evictions this week, the landlords, of course, if you were behind on the rent in August, the storm hadn't come, they're going to evict you. But if you were late on September, because you had to evacuate, most landlords will waive the late fees because of the disaster. Okay, and we found this to be, they were very cooperative and very compassionate. Okay, so unless you were a problem tenant, the landlord would say, I want you out of here. Just give me a reason to get you out. Okay, so it's best to go in writing. All right, now let's talk about some of the tenant's rights. Okay, let's say the decision is in favor of the landlord and is against the tenant. The tenant has the right to appeal. Okay, that's the wonderful thing about our country. Every judge's decision on up to the U.S. Supreme Court can be appealed. Okay? All right, now, the tenant has 5 days, 5 calendar days after the judgment to file an appeal. The tenant has the right, must put it in writing, a notice of appeal. It's best to go in writing. The tenant must post an appeal bond for the appeal amount on the judgment within 5 days to appeal. Okay, the bond is usually twice the amount of the judgment. Now, if there's no back rent, if the landlord says, well, I don't want back rent, I just want them out, then the judge will set a reasonable appeal bond. Okay? Now, if the tenant cannot afford to post the bond, the tenant can file with a statement of inability to pay. And that's what we call the SIP, or pauper's affidavit. Okay? And they must post 1 month's rent. It's due in the registry of the court within 5 days of that notice. And we give that to them in writing. The day that you have to post 1 month's full rent. The thing is that you can't live for free. You can't live for free. What we do is we don't count Sunday. We give them an extra day. I rule on Thursday, then the landlord can file for the writ of possession the following Thursday. Now, the tenant has the right to appeal up to Wednesday, okay, to stop the writ of possession. Once they appeal and they perfect the appeal, then the writ will not issue. Okay? Now, the rent is due. Now, remember, you have to post 1 month's full rent. And then you have to post 1 month's full rent each time it's due. It's due on the 1st. You got to post it in the registry of the county court at law. We move it on up to the county court at law. In the county court at law, you got to pay court costs. I don't know how they operate. I think that you can also file an SIP, statement of inability to pay on the court costs. Okay?
That's the tenant's
This is the
responsibility?
tenant.
That's the tenant?
Yes. Okay. Now, if it's not paid, the county court will send it back to the JP. The appeal was not perfected. And the writ of possession shall immediately issue. All right, now, on a month-to-month, the lease is expired. It's called a holdover, or there's no lease. And the landlord can, just doesn't have to give a 3-day notice. Landlord just give them a 30-day notice. Let's talk about some laws, and this is what we want to get into, to protect tenants. I usually get tenants in, and after they're being sued for possession and back rent, and their defense is, that house is raggedy. The landlord won't fix nothing. You cannot withhold rent. That's not the solution. You cannot withhold rent. All right? Now, repair and remedy. That's the suit where you can sue the landlord if it's a condition. First of all, it's got to be a condition that materially affects the health or safety of an ordinary tenant. Next of all, you can't be behind on the rent. Next of all, you can't file in retaliation because the landlord has filed an eviction. If an eviction case has been filed, you will be barred from filing a repair and remedy case against the landlord. All right? Okay, I want to make sure the landlord has acted in bad faith. You can terminate the lease, or you can seek the judicial remedy, and that is you can get an order to repair from the justice of the peace. Okay, that's one of your remedies. Now, the judge will give the landlord so many days to repair and remedy. Okay, if the landlord does not do it, the judge can hold him in contempt, put him in jail, and say, you hold the keys to your jail cell. We want this done. All right? Okay. Or else the judge can reduce the rent. Or else if the landlord acts in bad faith, the judge can award the tenant 1 month's rent plus $500. Writ of entry and retrieval. Now, we've been getting some of this lately. And that is, we have a lady who's living with a man. He's invited her to come in, and she's living with a man, even if she's on the lease. And he decides he's fed up with her. He kicks her out the house with the kids, and he locks her out, changes the locks, and says, you can't come back in. All right? So, I got it. All right. We have those situations, all right? Thank you. Thank you very much. Now, you can come in and you can file an application for a writ of entry and retrieval. I will hold an ex parte. Ex parte means I don't have to have the other side there. If they complete the application, we decide which items they're going to get out of the house. We list those items. Those have to be personal items. Can't be furniture, clothes, toothbrush, children's books, children's backpack, checkbooks, things of that nature that someone needs to live. Okay? Personal items, they're listed. And the constable will escort them to the house. We'll call the person living there and say, we're coming to get these items. If he says, I'm not going to open the door, say, well, you don't have to open the door. We're just going to pop it open. And they bring you in. They give you 30 minutes to collect those personal items. Okay? Okay, and that's called writ of entry and retrieval.
If you have somebody
Now,
on the lease too, how can somebody kick them out if they're on the lease?
I don't know, but they do. Domestic violence.
How can it be legal? I mean,
It's not legal. Okay? But it happens. It happens. The guy's fed up with it. He's mad with it. He kicks her out.
I mean, but if both of them
Haven't you seen that?
Can you guys or the council make him leave and let her stay there with her children? I mean, is it always, the person who kicks the other person out, they get to stay there, or can you guys order that person, and a male, to move out and let the woman and the children?
No. Not unless they're renting and the landlord kicks him out and the landlord files an eviction case. No.
My example was I said both of their names on the lease.
Okay. Nope. Well, we can allow her to go in and get her personal items, checkbooks, a laptop, computer, stuff like that.
Is there a fee for that, Judge?
Yeah, well, normally there is a fee, but usually when a person has been kicked out like that, they cannot pay that fee, so they fill out a statement of inability to pay, the SIP, pauper's affidavit. And I approve it. Okay, now, next we have the writ of restoration. Now, we have some landlords. I've had situations where the landlord comes and is mad with the tenant because the tenant is not paying the rent. They go to the breaker box, cut off everything, and lock the breaker box. Okay, I've had that situation. I can't believe they do something that dumb. But, okay, the tenant comes to my court, fills out an application for a writ of restoration. I meet with him ex parte. That is, the other side doesn't have to be there, ex parte. We sit down, and if I read the application, they convince me, I feel reasonably that, the landlord has interrupted utilities, and then I write a writ of restoration. Okay? Now, the landlord must restore the electricity. If he does not, I hold him in contempt, sit him in the jailhouse, and say, okay, you hold the key.
What time frame you give them?
Usually it's by 5 o'clock, 4 o'clock that evening. Okay? So, we have some landlords who lock out tenants. Okay? Now, let me tell you this. A landlord can lock you out, but they have to meet certain conditions. Now, generally, what they have to do when they lock you out on a residential lease, or even if the lease is expired, if they lock you out, they must post a sign on the door, on the entrance door, saying, you can get the key 24/7, call this number, and we'll come out. We got 2 hours to bring you the key. So some tenants play games and they call at 2 o'clock in the morning. The landlord gets there, 2 o'clock in the morning, 3 o'clock in the morning. Tenant leaves. He's laughing. He said, I made him come out at 3 o'clock in the morning to bring me the key. Ha ha ha. Then all the landlord has to do is post, say, I was here at 3 o'clock in the morning, now you have to come get the key from me. Okay? All right. But now, you asked the question, you may ask, I'm glad you asked. You may ask, well, why lock them out if you got to give them the key? Okay, generally, the reason for the lockout is because the tenant will not communicate with you, won't pay the rent, won't answer your phone calls, and you get their attention. Okay? So, that's how you get their attention. Huh? You have to let them back in. You got to give them the key. Landlord has to give them a notice. I'm fixing to lock you out. Got to give them a 5-day notice. Okay. And when they lock them out, they have to, leave a notice where they can get the key. We had a lady, she was a realtor, and she wouldn't give the security deposit back. They moved out. They left a notice. They said, here's where we're moving. You got to leave a forwarding address. And the landlord has 30 days. She says she refused to give them the security, refund the security deposit. Okay? They sued her. Came to court. She said, oh, they left the house in horrible condition. There were holes in the door, holes in the wall, broken out windows. Oh, it was a mess. And the tenant said, we can prove she's not telling the truth. They videoed the day they were moving out, their cleanup, and she said there was a hole in the door leading from the garage to the kitchen. They showed that. There was no hole in the door. And so I said, your response, ma'am. They showed the video. They even brought a television. I said, what is your response? And her response was,
Well, she's sworn under oath, but she should have been able to.
yeah, she should have. Well, she perjured herself too. All right, we could have pursued that. Huh? All right. Well, no, triple the security deposit. Okay, the tenant was awarded triple the security deposit plus $100. Okay, there's a heavy penalty for that. Okay, all right. Now, 3 times, treble damages, 3 times the security. If the security deposit was $1,000, you get $3,000, 3 times. If the landlord acts in bad faith, all right. It's in the property code plus $100. If it's uninhabitable due to the disaster, you can terminate the lease, get your pro rata refund on the rent. Okay, if you've been there 10 days, you get if you paid the rent, full rent, you get 20 days refunded, and you get your security deposit.
But I was wondering if you're staying in a house and it's a lot of people coming in doing work. I'm kind of feeling uncomfortable with all these people coming in my house with keys. I said, and none of them have proof that they work for you. She says, well, they work for us. That's all you need to know, they work for us.
The landlord is attempting to make the repairs. You got no recourse. And if you don't allow them in, you got no recourse. All right, we had a lady, housing was paying 100% of her rent. She goes and breaks something. She doesn't call the landlord. She calls housing to come out and fail the house. Housing comes out, fails the house, gives them 2 weeks to fix it. The landlord attempts to get in. She keeps saying, I'm busy, or I've got somewhere I got to be, I can't meet you. The landlord sets up an appointment, shows up, rings the doorbell, no answer. And they call her on the cell phone, and she said, well, I'm on the other side of town. Now, the house fails the second time. Housing cuts off the rent. So the landlord files eviction on her. Does that seem fair? You got to let them in.
Like if a person's apartment got completely flooded out where it's uninhabitable, are they still expected to pay September's rent if they haven't even been able to go back there? And also, do they get their security deposit back?
Let's say, for example, they are likely entitled to a pro rata refund. Okay, so if they had to move out on the 26th, they couldn't go back as of the 26th. And most landlords are very cooperative about that.
I mean, so I'm just saying, even if their lease might have went through October, but the place is still
Yeah,
uninhabitable.
you remember I told you, okay, if it's uninhabitable, then most landlords are very cooperative. You can terminate the lease, okay? Terminate the lease, you're entitled to your security deposit back and a pro rata portion of the rent. Okay, if you live there through the 26th, then the landlord has to refund 27th, 28th, 29th, 30, 31. He's got 30, the law says, let me repeat, the law says he's got 30 days to refund or itemize the things that were due to your negligence that he had to repair. It's a dollar amount. And then he must refund the remainder of your security deposit. Okay? And you have to give him the forwarding address in writing. And you cannot be behind on the rent. Okay? Yes, ma'am?
What happens if the damage is greater after you itemize? The damage is greater than the deposit.
And he just lost. He just lost. Okay? And now security deposit is usually equivalent to 1 month's rent. Now, if you are high risk and a landlord subscribe to, they look up judgments and stuff like that. If you are high risk, they can ask up to 3 times the security deposit because you're a high risk. So tenants, come on, remember that follows you. Those judgments follow you. Now, if you have a judgment against you, the reporting agency, the credit reporting agencies come in here every month with a laptop and they record the judgments. Okay? They record the judgments. Just want to let you know that. All right. Now, and then, of course, the apartment association, people who've been evicted, they keep a record on those people. Okay, and so if you subscribe to that, then they will give you the information. You say, well, John Smith, what about John Smith? And they'll pull it up. And they'll say, well, it has these judgments. Then you end up with having to pay triple deposit. Okay? Now, a judgment results in a lien. You have a judgment against you. It goes on your credit. You want to buy, some things change in your life. You want to buy a house. You need your credit. Okay? Now, you can pay it off. Pay the landlord and pay it off, and the landlord will release you. Now, I've seen cases where the tenant owed $3,000 and the tenant said, look, all I got is $1,500. And the landlord's just glad, tickled pink to get that $1,500 and said, I'll release you. Just bring me that $1,500. I don't know. I've seen that happen. I have seen that happen. Okay? Because the judgment's been out there for 3-4 years. He said, I'm just glad to get some money. I'm just kind of, well, I just wanted to let you know about that.
So it's
all right.
true in the state of Texas that they just get a judgment, but they can't collect because you can't garnish in the state of Texas. Right? They get the lien, they get the judgment, but they can't collect.
Well, there's post-judgment remedies. Writ of execution, if they have some non-exempt item, like a boat, art collection, gun collection, things of that nature. Or, okay, we had one guy, he was sued, but this was not eviction, but it was small claims, and he was sued, and there was a judgment for $2,500 against him. The plaintiff found out he had a lot over in, what's that, right out of Galveston, where the ferry goes. What's that called? Bolivar. Found out he had a lot in Bolivar. And it's not his homestead. And he executed on it. Believe me, he paid quick. Okay. And we had a lady who had a judgment against somebody, and the guy said, "I'm not paying you." She found out he had a yacht. Okay. You know, he had a cabin cruiser that he kept down in Kemah. She found out about it, and she executed on it. The constable went and got it, and confiscated it. Believe me, he paid her. Okay. So they wouldn't sell it. They can sell it, okay, to satisfy the judgment. Also, there's the writ of garnishment. And that is, if you know where they bank, you can sue the bank for that amount of money. The bank is going to take out $500 to $750 for attorney's fees and whatever is left. You have to prove that you have a bona fide judge.
Collect, is that just credit cards then? Because I'm in the state of Texas and Florida, and they can get a judgment, but they can't collect any money, can't garnish you other than child support.
You're talking about wages. I'm talking about a writ of garnishment where you sue the bank, and if they got any money in the bank, okay? I had a situation where a lady sued a guy. She got a judgment for $450. He wouldn't pay. She went and she filed a writ. Well, she had got a lawyer and filed a writ of garnishment. He had just made a deposit of $1,500 on that Friday. Froze the account. He settled because he had to pay his bills. Froze the account. That's where you sue the bank. Okay. And so that's called a writ of garnishment. Yes, ma'am. Well, the judgment's good for 10 years. 10 years.
Can you put that in a bankruptcy, the judgment? Can you put that in a bankruptcy, the judgment?
No. No, I mean, now if they file the bankruptcy during the eviction, then you got to go. Now, what bankruptcy courts like, if it's a rental property, you have to go and get a hearing at the bankruptcy court, and they usually will lift a home out of bankruptcy. Okay, so that's well, as a matter of fact, in every case, if it's a home, they'll lift it. They'll lift the bankruptcy from the home. They'll separate it out from the rest of the debts. Okay, all right. Now, the right to vacate, right to terminate the lease. You do have certain rights. Sex offenses. Okay? You have to have a police report. It's got to be for real. Stalking. You have to have a police report. Domestic violence, police report. All right? Okay. Like, for example, the husband is beating the wife, and she has the right to leave. She has a right to vacate. Okay? All right. Military deployment. Okay, the lease automatically stops. You can vacate the premises, okay? Now, we talked about mold. It's not enough. We have people come in and say, "There's mold in that house. I'm not paying rent. I'm coughing." Well, get me a doctor's statement. In Houston, Texas, we have a humid climate. And just about every house has a little bit of mold in it as a result of the humidity in Houston, Texas, okay? All right, so you're going to have, if it's bad enough, now especially now, you're going to find a lot of houses have been flooded or partially flooded. And you got to take out the sheetrock and spray it down with Clorox and try to kill that mold, okay? Or you got to get somebody who's a specialist in mold remediation, okay? But then, of course, if it's mold and it's making you sick, all right, you can vacate or terminate the lease. Just send him a letter and saying we got mold. But he's probably going to send out a mold expert just to make sure.
Okay, because I sent him pictures.
Sure.
And I put it in the text.
Yeah.
But he had someone to come and fix where it was leaking at, but he did not fix that part. To send a letter.
Put it in writing.
The
Okay.
text would be sufficient
Yeah,
as well?
put it in writing. You know what? I take a text.
Okay.
Now, if you're going to show me a text, you're going to give me your phone so I can go back and put everything in context, see. Some people want to show me a text and they want me to see what they want me to see. All right, but I'm going to look at the whole thing. Give me your phone. Let me just go back and let's go back 2 months and see what happens, you know. If you cannot afford an attorney, this is good timing, isn't it? Okay, if you cannot afford an attorney, Lone Star Legal Aid will help you, okay? They are funded by a grant, and they will help you if they feel your case has merit. Now, you got to understand, they have limited resources, so they may sit down with you to see if your case has merit. All right? And they may take your case, they may not take your case. So I can't say, but you can go to them.
When you say put things in writing, how important is it for people to send things certified mail?
Very important. Let me say this. If it has to do with real estate in the state of Texas, it must be in writing.
Hello, my name is Diana Waters. I'm a precinct chair for 1114 in the Fresno area. I'm also a community liaison for Senator Boris Miles. So you can imagine we endure and appreciate information to help our constituents and to help personally my co-workers and the residents of 1114 in understanding their rights as a tenant. I want to personally thank Judge Clouser, who's a personal friend of mine. He actually married me and my husband. But I want to thank him for putting this on. I'm hoping that he can do this in the future because I really think it's important for tenants to know what their rights are. I think the most valuable piece of information that he shared with us is to make sure we put everything in writing. And I respect the fact that some of the questions that were asked, he was given fair due process to the landlords who were not here in defense of the concerns that were raised. But again, it's a start. I'm looking forward to many more community outputs from the judge so that he can help all of us have a better relationship with tenants and landlords. So again, I want to thank you all for all that you do and keep it up. Thank you.
Hi, how are you? My name is Douglas Castillo. We're here to enjoy hear what he said, Judge Clouser, because we need to know about everything about when you get a contract with your apartments. So I really enjoyed it tonight. And if we had another meeting like that, the judge will be here because I need to know everything about when you get a lease with your apartment. So I'm really enjoying it tonight. Thank you so much.
My name is Lynette Howe, and I'm attending today the Tenants' Right session conducted by Judge Clouser. The session was extremely informative. What I'm taking away from the session today, the importance of the lease agreement. Various questions were raised. What should be happening, what should not be happening, but the focus, as Judge Clouser emphasized, the lease agreement rules. He additionally covered the eviction process, what should be happening after the eviction. But what I'd like to say, it was extremely informative. Judge Clouser took time out to give detailed instructions as to what should follow the law. I can tell you it was very helpful.